Almost every year, UPSC asks a question from the fundamental rights, and the number of question may vary from 1 to 3, 4. Hello everyone, myself Anurag Bharadwaj, and I bring the series of the videos of Indian political system for the aspirants of UPSC as well as other state PCS examination. With the help of these videos, we will see the comprehensive part of the Indian polity with the help of tricks and tips. So let's start the video. In today's class, we'll discuss about the fundamental rights chapter. As we all know that the fundamental right is a part 3rd of Indian Constitution, and this feature has been borrowed from the Bills of Right concept of USA that was implemented in 1787. And perhaps USA was one of the first country in the world that introduced, or one of the first democracy in the world that introduced the concept of right. But this is not 100% truth. Reason being, before the USA, the year was 1215 when for the first time the King John of UK brought the concept of Magna Carta. And this Magna Carta was nothing but the document where he signed the document to provide some privileges or to provide some rights to the feuds as well as the people living in their UK. And with the help of this document only, the ruler or the King John, he limited his power so that other people, so that middle class people can enjoy their power or their rights. So this could be considered as the beginning of rights, where later subsequently you will see that USA became the first country, first democracy of the world that introduced the Bills of Right. But in this series, you will see that India was one of the country. India was one of the most developing country that brought the concept of fundamental rights in a comprehensive manner, or we can say that our fundamental rights are comparatively more comprehensive than the Bills of Rights of USA. So, what is fundamental rights? What's the exact meaning of fundamental rights? We will try to learn this first. First of all, we will discuss about rights versus duty. What's the difference between the rights versus duty? See, rights and duty are supplement to each other. It's a dual concept where each one is dependent upon the another one. Let's say, for example, there are two parties, namely A and B, and these parties could be individual or a company or a country or a state. It depends completely upon the situation. But we can say that when the first one party is enjoying its right, then there would be second one party that has to pay some certain duties in order to fulfill the fundamental rights or the rights of an individual called first party. For example, when we talk about a family, in a family there would be some children, there would be parents or the guardian. Children has a right to get ample amount of education for their holistic development, for their complete development in the future. And on the other hand, now it's a duty of the parents or the guardian to fulfill all the demands regarding the education of those children. So it's a kind of dual concept. One has the right, another one has duty. In case of fundamental rights or in case of any right, you will see that the people or the individual who are living in a country, it would be the rights of those people, while on the other hand, it would be the duty of the state to fulfill all those rights that has been mentioned there in the written form. Here comes the second concept, and the second concept is rights versus liberty. Although you must have seen that the rights and liberty are the two words that are being used interchangeably, but there is a vast difference between the right and liberty. Rights basically are those which are justiciable in nature. Let's say, for example, there would be the third organ of the government called judiciary, which has the power or which has the duty to fulfill or restore all the rights of an individual which are being infringed or which are being curtailed by the state or other two organs of the government. So right could be considered as a justiciable part. There would be some certain limitations or the reasonable restrictions in order to prevent the person from being used those rights absolutely. But liberty on the other end is a kind of like open, or we can say like free concept, where there is no any restriction, whereas there is no any prohibition imposed by the state over the people from being used his or her liberty. So we can say that if we try to make a graph for these two concepts, so you will see that liberty is the bigger one concept, where individual is free to enjoy his or her rights freely without any constraints, without any prohibition imposed by the state, while right is the smaller part of liberty, where reasonable restrictions can be imposed by the state in order to enjoy these rights. This is the concept. Now we will see another one part. You must have heard about the multiple types of rights, namely natural rights, human rights, fundamental rights, and there are statutory rights, there are some certain legal rights. But from the point of view of examination, we will categorize all these categories into three parts, namely natural rights, human rights versus fundamental rights. What's the meaning of natural rights? We will see this, first. Again, natural right again is a kind of like comprehensive concept. This one is natural right, which is a comprehensive concept. By the virtue of being human, a person or individual is enjoying whatever is enjoying there in the nature, that would be his or her right, called natural right. Let's say, for example, being a human, I have a right to get fresh air. Being a human, I have a right to get fresh water. Or being a human, I have a right to get the basic elementary education. All these are my natural rights. So natural rights are nothing but the basic rights available to the human beings or the individuals by the virtue of being human. Okay, these are completely free from any restrictions. These are completely free from any kinds of we can say like prohibition imposed by the states. And that's why we can say that the individual or the people who are the citizens of another country, if they are moving or going or having water, having food in other countries, these one would be the natural rights of those people. While second concept is human rights. In order to understand the concept of human rights, it is almost same as natural right. As being a human, whatever you are enjoying, whatever you are getting, some certain privileges, these privileges would be treated as human rights. But there is a bigger difference, as human rights are those that were identified by United Nations Convention on Human Rights in 1948. A convention was held there in the UN in 1948, where some certain rights were identified, some certain rights were declared under the declaration in the Convention on Human Rights, and those rights were treated as human rights. There were total 30 human rights identified, where the number was 29 plus 1. 29 are actually human rights, and 1 is the implementing duty of the state to implement or to impose all these human rights there in the state. Is that clear? So basically, United Nations Convention on Human Rights is the mainly responsible convention in order to provide human rights or in order to ensure the human rights throughout the territory of the world. And as India is one of the permanent member of the UN, so it was the duty of the Indian government to provide or to implement all these human rights there in the India. Now here comes a third concept called fundamental right. What is fundamental right? As I told you, fundamental rights are those that has been mentioned under part 3rd of Indian Constitution. Whatever is mentioned there in the part 3rd in the form of rights would be treated as fundamental. I am repeating, whatever is mentioned there in the part 3rd of Indian Constitution as a right would be treated as fundamental right. But fundamental rights are those which are required by an individual for the holistic development of himself or herself. These fundamental rights are justiciable. Justiciable means nobody can curtail, nobody can, prevent you while enjoying your fundamental rights. It is the duty of judiciary, it's a duty of Supreme Court or the higher court of the India to address as well as to restore all those fundamental rights of individual that has been curtailed earlier by the state. And that is why this is the beauty of fundamental rights, that nobody can curtail them, nobody can, we can say repeal them. Nobody can curtail them. Now we will see the features of fundamental right. What is fundamental rights? Fundamental rights are justiciable in nature. As I told you, fundamental rights are justiciable in nature. It means in case of any kinds of infringement, in case of any kinds of violation of the fundamental rights, one can go there in the Supreme Court in order to restore them or in order to address them. These are non-absolute. Non-absolute means there are some certain conditions there are some certain reasonable restrictions that can be imposed on these fundamental rights from being used by an individual. For example, speech and expression is one of the fundamental rights that an individual can be enjoyed anywhere, but you have to maintain some dignity, you have to maintain the decency and morality. You will never speak against the integrity and sovereignty of the India. You will not create any kind of threat for the Indian sovereignty or the nation's sovereignty or the integrity. You have to maintain the law and order. You have to support the government in maintenance of the law and order. All these are the conditions under the reasonable restrictions that must be followed by an individual while enjoying their fundamental rights. Apart from that, these are non-permanent in nature. What does that mean? It's a power of the Parliament of India, it's a power of the legislature of the India to curtail or to repeal any part of the fundamental. And this is the kind of like, there is a story there in the Indian political system when a tussle was started between the PM, the then PM, Srimati Indira Gandhi and the Supreme Court of India regarding the amendment made by Indira Gandhi there in the fundamental rights. So we will discuss this part in the subsequent videos, but here you have to keep it in your mind that the fundamental rights can be curtailed completely, can be repealed completely, but this power is vested there in the parliament only. There is no any intervention of judiciary, there is no any, we can say like intervention of the lower part of the government. Second one would be citizen versus non-citizen availability. Some certain fundamental rights are restricted to citizens of India only. Some certain fundamental rights are limited to citizens of India only, and the number of such fundamental rights are 15, 16, 19, 29 and 30. These are 5 fundamental rights that are limited to Indian citizens only. In order to grab or in order to enjoy these fundamental rights, one has to get the citizenship of India. Otherwise, rest of the fundamental rights can be enjoyed by citizens as well as non-citizens. It means apart from these 5 fundamental rights, apart from these 5 articles, rest of the fundamental rights are available to all. Anybody, whether the citizen or non-citizen of India, can enjoy these fundamental rights. Next one is resemble political justice. There is a term called justice that has been mentioned there in the preamble of Indian Constitution, and in the Indian preamble you will see that justice can be of 3 types. Justice has been mentioned in the 3 forms, namely political justice, namely economic justice, and social justice or social justice. So, fundamental right chapter of the Indian Constitution deals with this political justice only. Fundamental right chapter of Indian Constitution deals with this political justice only, while the economic and social justice is provided by DPSP. DPSP stands for Directive Principles of States Policy. In the subsequent video, we will discuss this part also, but here you will see that the political justice is being ensured by fundamental right here in the Indian Constitution. Next one would be suspending during national emergency. It's a power of the central government, it's a power of the union government to suspend all the fundamental rights during the imposition of national emergency. If the national emergency is being proclaimed by the President of India, in that condition, all the fundamental rights except 220 and Article 21, all the fundamental rights can be suspended during national emergency. Keep it in your mind. Emergency can be of financial, emergency can be of state, while emergency can be of national emergency, but only and only in national emergency, all the fundamental rights can be suspended except Article 20 and 21. Keep it in your mind. It's one of the important part. So, these are the features where we have seen, although fundamental rights are justiciable in nature, but on the other hand, they are non-absolute, non-permanent, as well as some certain fundamental rights are available to citizens of India only, and these are 5 in number, namely 15, 16, 19, 29 and 30, while rest of the fundamental rights are available to all. Apart from that, these are the resemblance of political justice here in the Indian Constitution, while social and economic justice are maintained or addressed by DPSP, Directive Principles of States Policy. Last but not the least, during the national emergency, during the proclamation of national emergency, all the fundamental rights can be suspended except Article 20 and 21. All these articles shall be discussed there in the class in the subsequent videos. So kindly be with me to get all the information regarding these articles. Now we will see the types of fundamental rights. Types of fundamental rights. In the Indian Constitution, when the constitutional framer discuss about the fundamental rights, they try to cover all the dimension of the fundamental rights comprehensively, and that's why you will see that there are total 7 fundamental rights mentioned at the time of Indian Constitution framing. These are right to equality, that deals from Article 14 to 18, right to freedom, Article 19 to Article 22, right against exploitation 23 and 24, then right to religious freedom 25 to 28, then cultural and educational right 29 plus 30, then right to property Article 31, and the last but not the least, right to constitutional remedies, that is Article 32. I am repeating, Article right to equality, one of the most important fundamental rights, for which 5 articles were added, called Article 14, 15, 16, 17 and 18. It is a comprehensiveness of the equality, like we will talk about any kind of discrimination, we will talk about all kinds of discrepancies that could be happened there in the society. We discuss everything here in the equality. Second talks about the freedom, and freedom could be of like speech and expression, freedom could be of moving throughout the territory of India freely, freedom could be residing anywhere there in the Indian territory, freedom could to adopt or accept any kind of business, any kind of startup, any kind of intercourse. All these things can be possible here in the freedom rights. Next would be right against exploitation. Here we talks about exploitation of human beings. Here we talk about the begar, here we talk about the bonded labor, here we talk about Devdasi system, here we talk about the child labor. All these things are prohibited here in the India. Apart from that, there are some religious freedoms also. Again, it is one of the comprehensive concept where we will talk about the secular nature of India. As India is a secular country, that's why there is a comprehensive document called right to religious freedom, that talks about all kinds of religious freedom. It means being an individual here in the India, you can accept, you can adopt any kind of religion, its practices, you can perform any kinds of practices of the religion under some certain reasonable restrictions. Let's say, for example, if you are having some fast, if you are having some certain kinds of fast, you have to maintain the dignity, you should not be kill yourself while having fast there in the religious freedom. Apart from that, you will see there are some certain cultural and educational rights. These rights are also known as right to minorities. Minorities means those people, those citizens of India who are lesser in number, they are identified as a minority, and in order to provide some privileges to the minorities, we have mentioned a specific chapter called cultural and educational right. Apart from that, you must have seen this right to property in the yellowish color. What's the reason that I mentioned this in the yellow color? We will see this here. See, basically, right to property was mentioned there in the Indian Constitution, but it became the bone of contention between the legislature and judiciary, as when Indira Gandhi became the PM, Indira Gandhi created some certain laws. Along with that, Indira Gandhi amended the constitution multiple times in order to snatch these fundamental rights from the individual, from the human beings, from the people of India. And just because of that, ultimately, judiciary or the Supreme Court intervened in this matter, again and again. And because of that, this particular right to property was repealed through 44th Constitutional. It was repealed through 44th Constitutional Amendment Act of 1978 by Morarji Desai government. Morarji Desai government. So ultimately this right to property was repealed as a fundamental right and was shifted there under Article 300A in part 12 of Indian Constitution. 300A part 12 of Indian Constitution. So now it is no more a fundamental right, but right to property is still a legal right or a statutory right or the constitutional right of the India, but not the fundamental right. Last but not the least, right to constitutional remedies. What does that mean? Constitutional remedies means in case of violation or in case of infringement of the fundamental right of an individual, one can go there in the Supreme Court or the High Court in order to restore or in order to address the violation of those fundamental rights. So there are some certain writs, there are some certain tools provided by the judiciary so that these tools can be utilized by the judiciary in order to provide some certain privileges to the individual living there in the India. So these are the fundamental rights types. Initially there were total 7 fundamental rights, but in today's world, as of now, there are 6 fundamental rights. As right to property is no more a fundamental right, it has been transferred as constitutional right or legal right. So I hope you would like my video, and if you like, please subscribe my channel and do like, comment and share. Thank you so much. Thank you.